Number 6 to 11 to 23, number 40 to 33.
May please, your lordship. Lordship, I beg to mention item number 30 of today's list, lordship. Lordship, the justice service yet to be carried out, lordship.
Would not be.
Okay.
So you need fresh steps to be taken.
Fresh steps.
Okay, then counsel for the appellant to take fresh steps for effecting service upon the respondent,
Yes, for sole respondent.
sole respondent,
Obliged.
within 7 days. Thus, the service is permitted. Rule is made returnable in 6 weeks.
Yes.
May I please, your lordship?
Yes.
I beg to mention for listing, my lord. We read petition on Monday, my lord. I have filed in on 28 March, my lord. My lord, matter, my lord, already heard by this honorable court, my lord. This regarding, my lord, we have challenged the regulation of a 2021, which is adopted by the Higher Education Technical Department, my lord. My lord has given liberty to file a fresh because it was not heard because there is a subsequent amendment in the rules, my lord.
Okay, so you want it to be taken up on Monday?
Monday, my lord. My lord, recruitment, my lord, advertisement, online forms are already submitted.
All right, get it listed on Monday.
My lord. Obliged, my lord.
Yes.
Item number 1 of daily list for motion.
Surface I matter,
Yes, surface matter, my lord.
then why are we supposed to intervene?
My lord,
Go to the DRT.
my lord, we are ready to pay we have already paid more than 50% of the settled amount, your lordship. And we are ready to pay
So
the
you go
remaining 50% if your lordship allows us to pay.
What do you say? This is small loan residential property.
Yes, to a dwelling house, your lordship.
Your lordship, the property has already been auctioned on 21/12/2022.
Has the sale been finalized?
Sale?
Has the sale been finalized?
Yes, yes.
Sale is also finalized.
Yes, your lordship, the successful bidder, we have already confirmed the sale.
What can be done now?
And lordship, it is within the knowledge of the petitioner. Because on the very same day, he went to the bank to deposit ₹3 lakh.
Ah,
And lastly, when bank has told him that it cannot be possible, then he has deposited the same amount in his saving bank.
saving bank.
That the attached.
Sale has been confirmed, gentlemen. What can be done?
Lordship, may lordship take.
Is it a fact or not?
So far the sale is concerned, we are not having the knowledge, your lordship. So far the notice of e-auction is concerned, we have received that.
Mr. Counsel,
in fact, your lordship.
If the
But-
bank says it on affidavit
Yes,
that you are having knowledge about the sale being confirmed,
Lordship.
please read.
Your lordship, page number 39 of the writ petition. It is an e-auction notice dated 30th/11/2022. Thereby it has
Yes.
been clearly mentioned.
That is the notice.
Yes.
But you say that sale has been confirmed thereafter.
Yes, yes, Honorable.
Where is that?
Sale has been confirmed on 21/12/2022.
No remedy now, sir.
They can challenge sale certificate in the DRT also.
Challenge the sale certificate in DRT. That's the only way out.
In that case, liberty may be granted.
Liberty is always there.
Yes, sir.
All right.
Lordship.
The instant writ petition under Article 226 of the Constitution of India has been preferred by the petitioners against the proceedings initiated by the respondents bank for securing the loan advance to the petitioners by resorting to the proceedings under the Surface Act. This court is informed that even before the instant writ petition came to be filed, the secured assets had been sold and the sale has already been confirmed. In view of the above, manifestly, the appropriate remedy for the appellants would be to challenge the subsequent proceedings before the DRT, thus leaving the petitioners, don't mention appellants, leaving the petitioners at liberty to take recourse of the suitable legal remedy for ventilating their grievances, if any, comma, the instant writ petition is disposed of as being not maintainable.
My humble submission, till then, no coercive action will be taken.
Mr. Council, sale is confirmed. What more is required? What remains?
Yes, your lordship.
Then what course you measure now? They are not doing anything against you now.
Lord.
They already realized their secured their loan. Okay, account is settled. Next.
Item number 2,
I was required to take some instructions on the existence of two classes school. But I'm awaiting those instructions, little more time will be.
Council, Mr. Mozumdar prays for more time to obtain instructions in terms of the order date 24/2/2023. Council for the petitioner does not object.
But my lord, we have some urgency, my lord.
Don't, we'll take care of. List on 28th April.
item number 3,
Yes,
Lordship, the matter may be adjourned for the time being.
you want a pass over or adjourn?
Possible for the time being.
Okay, pass over.
item number 38 of supplementary list for motion.
Please, your lordship. And it's a very limited prayer that I wish to make before your lordship.
Yes,
My lords,
May I please,
loan
your
was
lordship?
sanctioned.
Copy has not been given to me.
again, surface matter.
My lords, the OTS really, may I say this, my lords, and I'm only making a small request, my lords.
Yes,
During the pendency of the surface proceedings,
Yes.
OTS scheme was offered by the bank to me. That resulted in the outstanding loan amount of 44 becoming 26 lakhs.
Mm.
Now, that was required to be paid within 3 months, extendable by another 3 months, that is 6 months with interest.
that period has gone.
That expires today.
Okay,
Now, once the sanction letter comes, these surface proceedings is halted. It will revive once it fails. The limited prayer I'm making, my lord, the lordship, the prayer is for 2 months, but if your lordship just grants me 15 days.
Six
Okay,
months.
number one, number
It's
two,
already
I
been
can't defend the
What is,
conduct, my lord.
what is the endeavor of your client in trying to pay that amount?
My lord, that is.
So OTS, you are indirectly
Your lordship is
asking this court
absolutely right.
to extend the OTS.
Your lordship is absolutely right.
What jurisdiction does the court have to do that?
Your lordship is right, but your lordships can persuade them. That is why I'm making.
I should, that's your, it's not our brief that we should try to
No, my
persuade
lord,
him.
Only request if your lordship so pleases, my lords.
go
15
to the
days,
bank.
my lords, it will be in the interest of both the parties if.
It would not be. The bank is losing a lot by offering the OTS.
But to again invoke the surfacey procedure in
Yes.
auction, and that may incur. Your lordship will grant me 1
They are
week's
not worried
time.
about it. Don't worry. Don't
your
take the trouble
Lordship
of
will-
reducing their
No, no,
inconveniences.
I'm not, my lords. I quite see what falls from my lord, my lord. May I request only 1 week, because he is in a position, my lords. Or may.
How do you satisfy the court that he has a genuine endeavor to pay the amount? What is the bona fide of this
My lord,
submission?
if upfront your lordship 5 lakhs we pay within your lordship, say 2-3 days,
Paid by 2 o'clock?
2 o'clock, today slightly, tomorrow if your lordship, 3 lakhs tomorrow, my lord.
No, nothing like, that's not done. 26 lakhs is the amount. 6 months you have not paid a single penny.
I paid 10%, my lord.
Oh, 10% is.
Your lord,
competence.
I don't defend, my lord, all those things, my lord. Your lordship.
We'll just ask if the bank is desirous of giving them any leeway. Yes,
I have just now received the copy, my lord. Just I am instructed to API, but as your lordship has a.
we'll post it on Monday.
Yes, my lord.
If at all you take instructions, if
Yes, my lord.
there is any scope for extension of 15 days, to take instructions today,
Yes,
tell us by Monday.
by Monday, yes.
Deeply obliged.
On my lord.
List
Deeply
on Monday.
deeply obliged.
Ms. So-and-so appears for the respondent bank and the respondent's counsel for the petitioner to supply copy of the petition to the counsel, Mr. So-and-so. What's your good name, please?
My lord.
MK Misra.
MK Mishra. Shri Mishra prays for and is granted time to complete his instructions. List on Monday, 3rd. Yes.
Matter number 4 of daily list.
With your lordship,
Yes.
this petition is filed for the implement of. the-
Implement,
Yes,
block application number so and so has been filed by the petitioner seeking substitution of the
Two.
respond number two from in the array of respondents on account of the fact that the officer holding the post has since been transferred. The application is accepted. You have filed the amended cost title. Amended cost title be filed within 3 days, list thereafter. Seeking substitution in the contempt petition. Number so and so, contempt case number so and so. If the council is here, take it. Other response council is here. Call it out.
Matter number 3.
Yes.
Lordship, this matter has become in progress
Okay.
due to the fact that the final hearing in the learned GRT is already over.
Already
The
over.
matter is fixed for judgment.
What do you say, sir?
Actually, Lordship, we have not filed here for any surfacing matters. Actually, we have only filed for the principles of natural justice being denied to us. That's the only purpose. For
What principles of justice, sir?
I will-
Whether you have been heard by the DRT or not.
Yes.
Yes, I have.
All right. What more do you want?
Lordship, this is the order of the law.
Can we anticipate, hold in anticipation that the DRT will not consider your arguments?
This is the order dated 55.
What kind of misuse of process this is? In every matter, even if the proceedings are already there before DRT, they have heard it, still you come up in red petitions.
Lordship, we had filed, but there is some reason over here also. The reason being is that we have paid the 50% and the account become a standard one.
So
when
why
the
DRT can't consider that? Why DRT can't consider? Let us know.
Okay, Lordship. As per your wisdom.
We are making it very clear. This expression is to be understood by all council. If we now find that this misuse of process is continuing rampantly, we'll start imposing cost. We make it very clear. This is too much. In every matter, DRT has heard the appeal, still a writ petition. Court is informed that the DRT has already, DRT or DRAT?
DRT.
DRT has already heard arguments on the appeal of the petitioner. And this was the matter, and Council Mr. Azad Mazumdar
Majumdar, my Lordship.
was liberty to withdraw the writ petition. Hence, the writ petition is disposed of as withdrawn.
My presence may be recorded.
Yes.
Oblige.
Matter number 5 for admission.
Yes, please. He may say anything, just hold on, sir. We'll ask you a question. Just hold on, please.
Yes.
What is the bona fide? What is the locus of your client?
My
To
client
challenge?
is-
Yes. He is an employee of the state government. Is he not?
He is the employee of the state government.
Your
I am
client,
the-
sir.
I am the secretary of the managing committee of the school.
Yes, all right.
And because of the complaint raised.
Who is
by
the transferring authority?
Transferring authority is the director.
State.
State,
State.
yes,
So, does your client draw salary from the state or not?
yes.
What authority in the eyes of law, your client have to challenge the order which is passed in a writ petition, setting aside the order of this state? What is the authority?
Yes,
Yes,
let me answer this.
yes, please.
I hope Lordship will be happy to find it.
Yes,
When the greater interest of the school, the academic atmosphere has been vitiated totally. And the action was initiated on the basis of the complaint raised by the managing committee, my committee. And the matter went to the authority, and authority also issued a show cause notice to him,
Yes,
and thereafter,
yes,
without taking it to the final stage of the drawing up any proceeding and all, took a temporary measure by transferring the person just
yes.
to save the school from being destroyed. The whole atmosphere of the school has been vitiated because of the conduct, and those things are admitted.
So let us
Yes.
see your authorization, please.
My lord.
Where is the authorization to the headmaster for filing this appeal?
My lord,
Let us see.
my lord, I was a party before the.
Maybe
No.
you are a formal party.
No,
Where is the
not party.
authorization to file the appeal, sir?
Authorization, I have made a statement, but then there is no such formal resolution placed before. the
You
Honorable
could
Court.
at best have come to the court upon being authorized by the SDMC.
Yes, my lord.
So where is the
because
authorization?
I'm the secretary.
We
of
want,
the
we want
school.
to see the authorization, please.
Then I'll have to place the proceeding before your lordship.
Yes, please.
Yes. Here it is not placed, I'll bring it.
Take down. This appeal has been preferred. Inter-court appeal is directed against, writ appeal is directed against the order dated
Order dated-
16/3/22, passed by learned single bench, whereby, the writ petition preferred by the respondent number so and so,
Respond.
cancelling is transfer, cancelling is challenging the transfer order dated 18/8/3/2019, passed by the Director of Secondary Education, Government of Assam, was quashed. We are at the outset, not satisfied about the locus of the appellant to file this writ petition, that this appeal. We therefore direct that the authorization, if any, issued by the SDMC
SMDC.
permitting SMDC, permitting the appellant to file the instant appeal, be placed on record. List after 2 weeks.
All right.
Item number 6,
List after 4 weeks.
Let him remember 2 weeks. It has to be enough. Lordship says 2 weeks.
How long do you want?
2 weeks only.
2 weeks.
Yeah.
2 weeks would take it to 4 weeks, sir, automatically.
Bihu, yes, after Bihu, that is after Bihu, after vacation.
Yes.
All right.
Yes, please.
May it please, your lordship. My lord, on the last occasion, I was not in a position to appear before your lordship. Your lordship has put a query that whether this relief which you are seeking before this honorable court has been rejected by the Supreme Court. So what remains alive in this appeal?
Yes.
My lord, if your lordship looks into the impugned judgment of the learned single judge,
Yes.
the learned single judge has relied on the judgment of the Supreme Court, which we had filed. And the fact situation of that case to SLP before the Supreme Court was completely different from the issues raised in this writ petition, my lord.
Can we have the copy of the SLP, please?
SLP is 2007, but the judgment is before in the judgment itself, the issues have been clearly reflected.
Very well. Let's see.
Yes, my lord. Your
Very
lordship will kindly see, my lord, 2007 3 SCC, page 73.
Then away. Give it.
My lord, I think it ought to be available online.
No issues, no issues. It will be available.
My lord, basically what survives in this appeal is that, my lord, this VLS scheme, which was promoted by the state for the employees of the Sikh public sector industries of Assam. My lord, all these employees who are the members of this union, my lord, this unit was closed down on 7/10/2008. And my lord, your lordship, the ROP 2010, my lord, it was made effective from 1/6/2008. So from 1/6/2008 to 17/10/2008, That period, my lord, for they will be entitled to the revised pay scale, which is under that scheme. After 2008, there can be no claim under any scheme of VRS. Now, if your lordship looks into the 2007-3 SCC page 73 judgment, my lord, your lordship will find that paragraph 1 and 2. Here, the question was that since, my lord, at that time, we were unsure of getting our salary and the part which were due to us. Then we raised a plea before this honorable court, initially before the labor court, that we are the employees of Assam Industrial Development Corporation. The labor court in its award, although it had held that we are not the employees of AIDC, but even then asked them to give our salaries. Then, my lord, the matter came before the writ, in the writ petition, in the writ appeal, it was dismissed because since there is a clear-cut finding of the AIDC, that we are not their employees, so their no salary will be entitled. And it is that issue, my lord, which went to the Supreme Court. It is not the relief that we were seeking here has been denied by the Honorable Supreme Court. Your lordship will see paragraph number 1 and 2, the backgrounds are given, my lord.
Yes.
May I read it for your? The appellant calls in question legality of the judgment rendered by Division Bench of the Guwahati High Court dismissing the writ petition filed by the appellant. The writ appeal was directed against the common judgment and order dated 7/5/2002 passed by the learned single judge, wherein the writ petition filed by the respondent number 2, that is management of Assam Industrial Development Corporation Limited, in short, the AIDC was allowed while dismissing the writ petition filed by the appellant. Both the writ petition were directed against the award of the presiding officer, Labour Court, Assam at Guwahati, hereinafter referred to as the Labour Court. The appellant claims to be the union of the employees of Messrs. Industrial Papers Assam Limited. Of course, this petitioner is the same. In short, IPL learner single judge held that there is a clear-cut finding in the award to the effect that workmen were not employees of AIDC, and therefore the question of giving them benefit, as was done by the Labour Court, did not arise, and consequently that part of the award was quashed. Background facts in a nutshell are as follows. The appellant, being the registered trade union looking after the welfare of his members employed by AIDC in his extensible sack kraft paper project for sake of brevity called as ESKPP, and the IPL raised a dispute for non-payment of salaries of his members by AIDC after October 1998 on the plea that the members of the appellants were not the employees of AIDC but of IPL. According to the appropriate government-wide notification dated 22 to 1999, referred the following issues to the Labour Court for adjudication. The issues are quoted below. Whether the management of Assam Industrial Development Corporation is justified to deny as owner of the sack kraft project of Messrs. Industrial Papers Assam Limited IPL, though they have signed an agreement with a contractor.
All right, we have read that judgment.
Yes, my lord. And
It is basically against AIDC regarding your relief against AIDC has been turned down.
Yes, my lord. And
No.
the learned judge just misconstrued and quoted this last two paragraphs and said that we are not entitled to that. That is not the issue here.
The entitlement is being questioned on the ground. How do you explain the delay?
Yes, madam. Madam, your lordship will see the learned single judge has referred to paragraph number 15 and 16.
Yes. Sir, we are putting you a question.
Yes, madam.
There is one observation regarding delay.
Yes, madam.
What is your answer?
My lord, so far, my lord, the delay part is concerned, my lord. Although we are entitled in 2008, our payments were made on 2010. When some of the payments were made on 2010.
Yes.
From 2010 to 15, my lord, when till the time that my lord, this matters came up before this honorable court. It is not this only this unit has come up before this honorable court. So we at that time all the industrial units of Assam, I think around 15 or some units have covered. They were in negotiation with the government of Assam. And when it was not paid, my lord, a union like us, all they came up before this honorable court in 2015, and this honorable court by various orders in different separate cases have granted them the relief so far they are entitled. And the government took the matter up to the Supreme Court also in a separate set of SLPs that were all dismissed, upholding the orders of this honorable court. So there is no such as delay in approaching this honorable court, or the Supreme Court has also never questioned because they were in negotiation with the government. It is now, my lord, we are only a limited prayer to the extent that whether we are entitled to the revised pay scale from date of 1/6/2008, so 2/17/10/2008,
Yes.
when ROP is made applicable. And so far the funds are concerned, but in that case which I have just referred, there AIDC, that fund position and all are there, that the court left the option that you, since the High Court is also in session of the matter in different cases about the payment of salary and all, but those were never put to us on notice. So funds are available. We have made the statement and the communication also says that funds are available with the government under this scheme to pay us that revised pay scale and certain other benefits, Malad, which are due under that ROP 2010, Malad. That's the only limited prayer which is available as on today, my lord. And now they say, Malad, this money, Malad, which is now available with the liquidator to give us this payment, they say that he can't withhold it, but the government doesn't take any action. The communication says that funds are available. So these matters ultimately went to the Supreme Court in the separate SLPs and all of them have been dismissed in limine, upholding the orders passed by the single bench and the division bench of this court. And only
What orders?
the orders passed for similar writ petitions which were moved before this honorable court.
Can we have a look at those orders?
It has been referred as, it has been referred in the order also, my lord, at page 112, paragraph number 3.
Yes.
112, your lordship got it, page number, paragraph number 3.
Yes.
The learned senior counsel for the petitioner submits that the relief claimed by the petitioner squarely covered by the ratio law laid down in the case of all Assam state fed curvature so-and-so reported in so-and-so. The learned senior counsel for the petitioner submit the said order was unsuccessfully challenged by filing WA number so-and-so, and thereafter it was unsuccessfully challenged before the Supreme Court India by filing SLP number so-and-so, which was dismissed by order dated 7/12/2000. Accordingly, it is submitted judgment dated 3/1/2000 passed by this court in all Assam state fed has attained finality. So, those are not in dispute that we are not entitled to the allowance and so on. These are not in dispute. But in some of the cases, because the employees have retired or the units have closed prior to the application of ROP 2010, that's why they will not get the benefit, because once you get that closer unit is closed, you cannot ask revision of pay or any other dues, because under that scheme you are said to be have given a golden handshake. But prior to the closure, you are entitled to the benefit. Since this unit has closed in 2008 and the ROP has come in 2006, that some amount they may get, the peon may get some money, the clerk may get some money. These are all those employees, my lord, who only that relief survives, my lord. Because we have paid, my lord, medical we have paid, leave engagement we have paid, salary also to up to 2008 till the closure, we have been paid, my lord. Only that
So
balance
allowances,
of
only few part of the allowances.
yeah, a few part of the allowances and that revision of pay scale, that's a small fraction that which they calculate by all those DA calculation and all that I will get. And funds are sufficient, funds are available. That's we have
right.
brought it on record.
Yes. Yes, please. Who's there?
Hello, my senior standing counsel of AIDC is next on another court matter right now.
AIDC has nothing to do with it now.
Yes, yeah, this is nothing.
Who is appearing for the?
Lot of Council of Industry Department is necessary. Lot. If I'm appearing for Finance Department, Lordship may kindly see the impugned judgment, Lordship, at page 114.
Yes, we've seen that. The question is, they are asking for the relief as was granted to the employees in all Assam's state-fed Karamchari Munch in the same terms.
In that judgment, Lordship, three benefits were given. That is one house rent allowance, medical allowance, and city compensatory. That has been granted.
To them?
Yes, Lordship.
Already?
In the present case also, they have been granted. They are for additional, Lordship. In the petition, Lordship, several periods were there. Now they are claiming area salary.
And what about Arun Kumar Das?
Same judgment, Lord.
What about?
In Arun Kumar Das also, State Paid Employees Association was followed, Lord.
Same relief.
On the same.
And same relief has already been allowed.
They have been given, that much they have been given.
Then what
Now
remains
they are-
with
they are
council?
No, my lord, that's factually incorrect.
No.
But we have filed a contempt. This period from 1000, from that 2006 till the closure that 2008, that revision of pay has not been given. And
Where
we
have you
have
said, just hold on.
Yes.
Where have you said in your counter affidavit in a position that relief in terms of these two judgments have already been granted? Please let us see.
Lordship will see the judgment itself, Lord.
Judgment.
Yes,
Okay.
Lord.
Which one?
Page 114, Lord.
Yes.
Last line, Lordship. In view of the discussions above, last paragraph, Lordship. Therefore, rule is made absolute in terms of relief granted in paragraph 7 above, Lordship.
Paragraph
Lordship
7.
may kindly see paragraph 7.
Yes. This is,
113.
but the revision of pay has not been given.
Yes, Lordship, because Lordship, they are a public undertaking, Lordship, and the
Okay.
revision of pay is not automatically applicable to them. For that, the board needs to have a resolution, Lordship. If they have taken the resolution, the employees are entitled to revision, Lordship.
Okay.
No such revision was taken, no such resolution was taken.
Was taken by the board. All right.
That is one, Lordship.
Mm.
And so far as area salary is concerned, Lordship may kindly see 114.
Yes.
Lordship, it has been extensively dealt with by the learned single judge at paragraph number 8, Lordship. May I read, Lordship? As regards prayer number 1 for area salary is concerned, the learned senior counsel for the petitioners has submitted that the members of the petitioner number 1 union have not received their area salary. In this regard, as already indicated above, the revision of pay, which came into effect after VRS notification dated 15 to 2016, had come into force would not be applicable. Moreover, with regard to the said claim, it would be relevant to refer to the.
So this has been denied only on the ground that this demand has been made after unreasonable delay.
No, delay was for, there is a relay on Lordship, that paragraph number 16, Lordship.
That is, you see, Mr. Counsel, that judgment we have seen, that judgment only says they can't seek relief against AIDC.
No, they have been said that on in terms of court's order, one committee is already there.
Yes.
You need to place your grievance before that committee. Lordship, whether they have availed that benefit or not, after they came to the court after 8 years, and that was
Where is that observation?
paragraph 16, Lordship, at page 114.
Committee has been appointed.
Yes. It has been submitted by the learned counsel for the appellant. It is by the Supreme Court, Lordship. The appellant that the committee has been appointed by the High Court in the matter of area salary.
Yes, yes.
And on the question of objection of various Sikh public sector undertaking. Now the learned single judge says, Lordship, the said decision was rendered by the Supreme Court of India on 10/1/2007. Therefore, it is presumed that the petitioner number 1.
So they are silent about having approached the committee. They are silent.
They are silent.
Yes.
That was the
may I respond to it?
delay ground was taken on that aspect.
Yes.
My lord, the learned single judge with utmost respect has misconstrued the observation made by the Honorable Supreme Court. At paragraph 16 of the Honorable Supreme Court's order, my lord,
Yes.
the committee has been appointed by the matter in the matters of various areas of salary. My lord, at that time, this amount of which were paid city compensatory allowance, the house rent allowance, the medical allowances, we had no other option. That's why we approached the AIDC. But later on, my lord, there was this committee as such was not of the High Court, but the government then came up with all this scheme and started paying us money from them. Therefore, this
Have you
reading of
denied,
this issue-
have you denied this fact that no such committee was ever constituted?
My lord,
Is
in the-
there a denial?
Yes, sir. My lord,
Where is, let us read.
yes, sir. Yes, madam. Your lordship will see the grounds.
Yes.
Madam.
In appeal,
Yes, madam.
read.
Yes, madam.
Yes.
Madam, just a moment, madam. I read it in the morning, madam. At page 23,
Read, please.
page
Yes.
23, paragraph number 6.4. Madam, there is no denial to it, madam. Paragraph number 23. For that, the Honorable Supreme Court in the case of Industrial Papers Assam Limited versus Employees Union of Management AIDC reported in AI 2007 SC 985 has upheld the right of the concerned employees or recognized union to make claims for areas of salary or claims to be due from IPL, and for which it was also noticed by the Honorable Apex Court that a committee has been appointed by the High Court in the matter of areas of salary. However, the said committee having not made any subsequent decisions or
Mr.
recommendations.
Counsel,
Yes,
question here is, did you apply to the committee?
Madam, we had,
Committee?
Madam, our grievance, this is in respect of salary. So far salary is concerned, madam, we did not have any grievance because salary has been paid up to the date of closure. It is only on the
Therefore,
case of
arrears.
revise.
Arrears, revised pay scale, everything would be within the scope of the domain of the committee. Why not?
Madam, that committee as such was not there. This
Mr.
committee.
Counsel,
which the-
please
Yes.
don't make a misstatement.
Yes, madam.
You yourself say that committee has not taken any decision.
Yes, madam.
Does it now lie in your mouth, or does it lie for you to argue that the committee was never constituted?
No, madam, I'm that they have to.
You
clarify
are
because
not aware.
Madam, so far our the utmost respect I am submitting. Madam, so far our these are concerned, it is settled by the liquidator. And the
Okay.
liquidator had fund. We had approached the liquidator that give us this dues, my lord. There's no such committee. The liquidator has all the funds. We have approached the liquidator, my lord.
Where is the order of the liquidator?
My lord, your lordship will say that our representations and the liquidator's last order, my lord. Your lordship will kindly see, my lord. Just a moment, my lord.
Hmm.
My lord, just a moment, my lord. Just a moment, I had it, my lord. Just a moment. एक देखो तो लिक्विडेटर को बोला है पैसा ये है बोल के मतलब just a moment.
We have granted you 3 moments.
Yes, yes, madam. I am obliged. At page 66, madam.
Yes,
The communication dated 6/4/2015, madam.
yes. 66.
Yes, madam. Annexure 9, madam.
Yes,
Madam, your lordship will see the content. Revised pay scale and other liable payable to VRS employees of Industrial Papers Assam Limited, madam. Page 66, Annexure 9, madam. Your lordship got it.
yes. Is it to the OL?
To the director by the, my lord, Deputy General Manager, Technical of AIDC
You
Limited.
just now said that you apply to the official liquidator. Is he the official liquidator?
No, madam, the government has said that these are the funds available with the government, then they can pay only subject to the approval of the government, madam.
Please be firm on your stand.
Yes.
You said official liquidator.
Madam, I'll see my representation, madam, to which it was addressed. Representation thana 52 say. Look, hey. But the first representation is at page 62. Page 62 and 65 are the representation, but it is addressed to the appropriate authorities of the government who can pay us this money, madam. I got little confused because, madam, in all
There is
these
a
cases.
committee you don't know.
Yes, madam.
You say that you approach the liquidator. Where is that liquidator application? You don't know.
Madam, no, madam, that is not, madam, what, in all these cases, right from state fed, I was appearing in that state fed case also. It is the liquidator who handles all these funds, madam.
Council, there is a clear finding in the Supreme Court judgment.
Yes, madam.
Committee constituted. If there was no such committee, you should have filed a review before Supreme Court saying that, sir, there is no such committee. All right. In these pleadings, do you mention anywhere that there is no such committee? No. You say committee has not taken a decision. When did you apply to the committee?
My lord, that committee has, that meaning of that committee has lost its meaning once that schemes comes into force and we are paid.
Okay, understood.
And
Thank
once
you.
that we are paid,
Very
and
well.
we have submitted the representation, your lordship will see at page 62. These
Yes.
are the appropriate authorities of the government who can take a call on that decision, my lord,
Very
page
well.
62 and 64.
Yes.
So far, the liquidator application, my lord, if it is there, I will need to clarify it from my, the appellants, my lord.
This
If-
argument was raised by you, sir,
Yes, ma'am.
that we filed the application. So if it is there or not,
Yes,
that is not for us to find out.
yes, yeah, definitely.
Yes.
But whether in terms of that Supreme Court order was prior to all these payments were made.
Very
Malad,
well.
once that payments were made, Malad, the salary and all, we raised the grievance that we are entitled from the date when the ROP is applicable till the date when the closure unit is done. That to that time it has been entitled.
All
And
right.
then the learned single judge, relying on a judgment of 200 judgment of the honorable, 100 judgment of the Honorable Supreme Court has been relied on, which is also the factual situations are completely different. It talks about of Hindustan Fertilizer Corporation and that earlier Fertilizer Corporation of Limited. There the issues are all different, saying that we are not entitled to this
Yes.
because we have raised our claim after our payments and all.
Yes.
Because up to 2015, the communication that I have just referred, my lord, your lordship will again look into that communication for the time being, my lord, at page. ये अभी जो दिखाया था, ये तो है वो कमिटी को जो दिया था अभी, वो करो, नहीं अभी जो दिया था वो जो कमिश्नर ने लिखा था, अभी जो दिखाया था ना, नहीं वो रिप्रेजेंटेशन है, वो जो कम्युनिकेशन पैसा है बोलते, your lordship will again see, my lord, page 66 at annexure 9, my lord.
Yes. Yes, please.
The contentious of it.
Yes.
With reference to the above, it is to be noted that Industrial Paper Assam Limited was declared closed by notification dated 17 October 2008. And the employees were given VRS in the revised pay scale of 1996 as per government orders. Petitioners of Employees Union, by their petition dated 25/2/2015, has paid for 7 point liabilities in the prior. Point-wise findings are as follows. Revision pay scale of areas from 1/1/2006 to
Mr.
October
Counsel,
2008 to be paid.
The first issue you need to answer or address yourself. Supreme Court says Assam government has nothing to do with it. That is closed. To whom are you making the representations?
Well, to the Director of Public Enterprises Department, my lord, who is managing all the funds for, they are the provider of the funds, my lord. It is not that this Industrial Papers Assam has the fund, my lord. It is the Public Enterprises Department who has to provide the funds.
That becomes now a disputed question of fact.
No, my lord, it's not disputed. It's they have admitted that funds are available, my lord. We have those communications, my lord.
Very well.
That
Okay.
funds are available with with them. Only thing is that, my lord, they say that 2008, we are not. Then now we also will see.
Yes. Very well. Anything else to say?
This is all, my lord, because denying, my lord, when funds are available for closure of this unit, and we have claiming or prior to the closure of the this unit, the dues. If the government decides not to pay it, my lord, then we'll have to test it, my lord.
Yes.
There's no other way, my lord. And what we will get is that, my lord, the notice period of 3 months salary will get some amount of gratuity or gratuity also, my lord, we got some amount.
Okay.
Then we'll get that revised pay and some other allowances which are due from till the day that is
Yes.
to be closed, my lord.
Very well. Why can't you approach the labor tribunal for this purpose?
No, labor tribunal is for different purpose, my lord. Labor tribunal, if we is not required to be approached for the relief we have sought in this, unlike all the other units who have come to this High Court, and the government has taken the matter up to the Supreme Court to deny us the benefit. We have not got it. Their petitions were dismissed in limine, my lord, in limine with a single line order, my lord.
Very
Not
well.
even the Supreme Court bothered to enter it.
Very
Now,
well.
if they don't pay us this unit, my lord, we'll test it. There's no other wait for us to go.
All right. Okay.
Deeply
Yes.
obliged, my lord.
Yes, please.
That's all, Lordship. Only one paragraph I would like to refer, Lordship.
Yes.
Page 96, this is the affidavit filed by the Finance Department, Lord.
Just 96.
Paragraph 4, Lord.
Yes. Hmm.
Now, here
This
we
is
have
finance.
stated as per
Finance affidavit,
Lordship.
finance department.
Yes, Lordship, in the petition, Lord.
Yes.
So here we have stated that the deponent bank, state government released rupees 127.14 lakh by sanction number so and so dated 2008 for BRS, etc. And another amount of 427.435 lakh by sanction number so and so dated 2010 in respect of revised BRS, etc. as per ROP 1998 on the basis of the cabinet memorandum
Yes.
on closure liabilities prepared by the Public Enterprises Department and duly approved by the state cabinet against a demand received from the concerned department employees of industrial papers were released under revised BRS notification number so and so. So there is a notification of 2006, Lordship. As per that notification, whatever needs to be paid, Lordship.
That has already been paid.
Lordship. And that notification is not under silence.
Yes.
My lord, just a short reply because he has pointed out this paragraph number 4.
Yes.
Because I know that it will be a useless now to point out all these things, but even then I'm pointing out to your lordship, this, although this is talks about the notification of 2006, if it was there, then you have out of charity, you have paid us till 2008 the salary. Because the unit was operation till 2008, our services were taken till 2008. That's why you paid us 2008. If you are talking about this 2006 notification, then this from 2006 to 2008, they are paying it from their own pockets. It's not. And what we are asking from the government is the fund earmark up to 2006. We are beyond these two funds that they have been earmarked in paragraph number 4. We are not paying. We are beyond that, my lord.
Okay. Very well.
Obliged, Lordship.
Matter number 7.
My lord, I'm praying for some more time. Bring the records back.
My lord, subject to what your lordship may say, my lord.
Yes.
I think on merits, I cannot challenge the petition because only my lord, prayer which I would make, my lord. My lord, this petitioner, he was appointed, only one fact, my lord. He was appointed in the year 94. And at that point of time, he had HSLC qualification, grade 4. And besides this, my lord, HSLC, he has got computer, some courses and certificate of typing, etc. But 2000 and that time qualification was, my lord, 7 years experience for the purpose of consideration of promotion to the post of junior assistant. Now this qualification has been changed in the year 2015. But despite this, my lord, 2018, I was promoted wrongly, my lord, I admit that. So what I pray, my lord, your lordship will kindly see page 83.
Yes.
Page 83, one page only. When, my lord, education criteria are changed, some relaxation is provided to the my lord, persons who did not have the qualification, so that they get the qualification within a particular period of time. So this, my lord, in respect of the persons who did not have B.Ed degree, my lord, in education 83, my lord, hereby pleased to order that the candidates without B.Ed, because B.Ed was brought in, degree shall be eligible for appointment in higher secondary schools during the period 1st January 2015 in relaxation of educational and professional qualification as per provisions under 2012. Because 2012, my lord, that B.Ed degree was brought in. However, such candidate must acquire B.Ed degree from any recognized university within 5 years. So similarly, my lord, page 44 also similar exercise was made by that relaxation.
So, but why doesn't your client acquire that higher degree?
No,
What is the problem?
No, now, my lord, this has been changed, my lord, in the authorities came to know in the year 2018. 2018 also authorities did not know, but therefore they have promoted me.
Yes, but now whether that has been reversed, that decision must have been recalled.
No, that decision subsequently they have gone for advertisement. There I have nothing wrong.
Then
I don't. Only thing, my lord, what I possibly pay with your lordship is that the relaxation provision is here. So relaxation provision is in this rule also.
Yes.
Rule
Relaxation in what criterion? Is it educational criterion?
That is educational, because now the education has been brought to from earlier it was HSLC, now B.Ed, now bachelor course. So what I pray, my lord, they can also consider here also that you pass BA within a period of 6 years, 7 years, or 5 years. In the meantime, relaxation. I'm not saying the court doesn't have the power. What I'm saying, my lord, the petitioner will file an application, they will consider under Rule 15.
What do you say?
My lord, in that case,
I think
my lord,
because
you can always file a representation, man.
Yes, then you consider it as per law.
As per
What else?
15.
Let's see the rule.
Yes. Rule 15 of 1967 rules. Because similar provisions when, my lord, education qualification is changed, my lord.
And what about the advertisement? The posts have been filled?
Advertisement, after that, there was a stay, my lord, then thereafter what? No, they have not made.
Has been made by this honorable court, my lord. Instruction has been awaited, my lord, with regard to whether the post has been filled up or not.
No, I'm not
So,
going
my lord,
there
I'm
because
praying
I
for some.
found,
He's not going on that.
because I found, my lord, the post fell vacant in the year 2017. So 2017, it will not work because the qualification was changed in the year 2015.
Yes.
So the only thing is, well, relaxation. When qualification is changed, my lord, government normally relaxes.
Rule 15.
15, my lord. Page 205 in this book, my lord. Earlier it was, my lord, HSLC, 7 years experience.
Hmm.
Now this HSLC has been changed to my lord graduate.
Hmm.
As your lordship of review. I'll file an application, the petitioner will file an application, they will consider it. This is the only possibly, my lord, prayer I can make before this court, subject to what your lordship is saying.
What we are asking you,
Yes.
why doesn't your client acquire the degree and then apply?
No, my lord, but in similar circumstances, as I have shown, my lord, when the qualification was changed, that besides graduation, you need B.Ed.
Hmm.
So government has, my lord, in power of in exercise of that relaxation power, government said, all right, you will be now considered, but you will have to take the degree within a period of 5 years.
With regard to my
B.Ed degree.
BT and B.Ed.
Yes,
It's after
BT and B.Ed.
graduation, madam.
Yes, that is all, but here, my lord.
All right, you reject his representation. You're not saying that you must accept it.
They should consider it, my lord.
All right.
Provision is there. In similar
Dispose of
circumstances.
giving liberty to the appellant to move a representation to the competent authority under Rule 15 of so and so, which shall be objectively considered. I'll,
As per law, my lord.
as per law,
As per law.
dispose it.
Did-
My lord, they will consider it in his, otherwise he will.
Within a reasonable period of time.
Yes, my lord. I'm deeply obliged.
Item number 8,
Yes.
May I please answer? Well, the order of the learned single judge, lordship will find at page 114, madam,
114.
114, madam. Well, the issue before the honorable court was as regard cancellation of the selection process, madam. In
Entire
respect of-
process.
madam, in respect
There were
of-
4 posts.
in respect of 2 posts, madam,
Okay.
two posts pertaining to Kachar district, madam.
Hmm.
Well, the speaking order was passed, it was cancelled by passing a speaking order pursuant to lordship's, the honorable court order by an order dated 11/1/2018. Well, when the authorities found that
Yes.
how
Your rate appeal is after 4 years.
rate appeal is after some delay, my lord,
Some.
delay has been condoned, my lord.
Oh,
Now the delay has been condoned. Now this has come for admission, my lord. My lord, in fact, in the affidavit, my lord, we have given the list, but kindly see, my lord, the conclusion of the honorable court, my lord, at paragraph 10, page 119, my lord. From the above extract, it may be seen that the result of the viva voce have been withheld after the respondent number 2 on being verbally informed that a few applications were left out in his office and therefore necessary action may be taken in the matter. The reasoning given by the respondent number 2 in my considered view is vague and cannot be accepted inasmuch as no specific detail about the left out application as mentioned above. And there is no formal communication from the office of the district social welfare officer Kachar to the respondent number 2 so as to justify such an action.
hmm.
It may also be seen that it is not even a case of the respondent authority concerned that the complaints have been received about non-consideration of applications submitted by the applicants for the post of LDA cum typist. Therefore, the respondent concerned, more particularly the respondent number 2, in my considered view, cannot withhold the result of the viva voce test on such ground. Further, the submission and stand of the respondent number 2 that the application of the petitioner for the year 2004 was not found cannot be accepted inasmuch as the petitioners were issued their respective admit cards. Look, Lordship may kindly come to the affidavit and opposition filed in the matter, my lord. At page 99 is the affidavit. And annexure 1,
Viva voce test was never conducted.
Lordship,
It was not conducted even.
no, it was conducted, my lord. Viva first, my lord, there are 2 posts, total 4 candidates participated in the process for the written. The result was declared 2 passed the written and they were called for the viva.
Viva.
Ultimately, only the authority found that 347 applications were not even forwarded. Those
Or written examination.
were written examination. Those were even not considered. My lord. In the affidavit, we have given the list. Kindly see, my lord, annexure 104. Sorry, page, my lord.
What action have you taken against the officer who withheld those applications?
My lord, those are left out in the district office. Subsequently,
Was there supposed to be any disciplinary action against those people?
Malad, that, what action that, Malad,
Because this is too serious either ways.
True, Lordship.
Either this is a made up case.
True.
If not, the person concerned may be for giving benefit to these two people.
Lordship.
Without the other applications.
Lordship.
So as many as 357 candidates,
300
they were deprived from applying against the post.
those were not even forwarded to the director.
So they were deprived.
Lordship, they were withheld.
What is your affidavit? Let us see.
Well, affidavit starts at page 99. Kindly come to the page 103, Malad, the list of 347 candidates. These are the list, Malad. This is filed. Affidavit starts at page 99.
Read.
Lordship. Malad, paragraph 4, where page 100.
Just hold on.
Lordship.
Para 4. Read.
Para 4, Malad. The answering deponent respectfully submits that as per report by number so and so dated 14/1/2019 submitted by the District Social Welfare Officer Kachar, total 347 number of applications for the post of LDA cum typist had been received by this office in the month of March 2014. According to the said report, the applications of the petitioner for the selection process was received by the office of the District Social Welfare Officer Kachar in the year 2012, and no such application for the petitioner applying in 2014 is available in the office records. The answering deponent state that as regard the total number of applicants who directly submitted their application to the District Social Welfare Officer for the post of LDA cum typist in the Kachar district, the office of the answering deponent sought detailed information from the e-Gramin Services Private Limited. Accordingly, the information has been received from the manager e-Gramin Services Private Limited on 3/5/2019 with a list of applicants and their details who had directly taken part in the recruitment process, wherein the name of the petitioner is reflected as serial number 4 to the list. Kindly see the list below at page 103. These are the list of 347 persons. Those were not at all considered. In fact, not forwarded to the director's office.
What action have you taken?
So that Malad, of course, I'll take the instruction, Malad. But because of this reason, Malad, the order was issued by the authority cancelling, withholding the declaration of result.
Yes.
That Malad will find at page 68. This is the order. The speaking order passed after the honorable court order, Malad. 68. It starts at page 68. Kindly come to page 69, Malad.
Yes.
Whereas on verification of the records, it is seen the result for the post of LDA cum typist was not declared, along with the result for the other post. As per available records, 2 posts of LDA cum typist regular was earmarked for the district, Kachar district only. Candidates of the Kachar district could apply with employment exchange registration only from Kachar district should apply for the post as per advertisement notification published by number so and so dated 24th of February 2014. As per the said advertisement, applicants had to submit their applications to the District Social Welfare Officer Kachar. The District Social Welfare Officer Kachar was asked to send those applications to the Directorate of Social Welfare Assam in due course of selection process. But later on, after written examination and viva test were completed, then the Director of Social Welfare informed verbally. In fact, the letter is also there, Malad. Verbally that the director that few applications were left in his office and requested to take necessary action in the matter. Therefore, it was decided not to declare the result of the 4 post of LDA cum typist keep pending in the matter. But subsequently, the other 2 posts for the Jorhat district, those were declared and those were filled up. Malad. In only dispute is as regard 2 posts of Kachar district.
Right.
But Malad, the learned single judge, while passing the impugned judgment,
Yes.
Malad, at paragraph 10 came to a conclusion that there is no the detail has not been given. Kindly at page 119 I have read. I'm taking your lordship again, Malad. It may be from the above extract, it may be seen that the result of the viva voce test have been withheld after the respondent number 2 on being verbally informed that few applications were left out in his office and therefore necessary action may be taken in the matter. The reasoning given by the respondent number 2 in my considered view is vague and cannot be accepted inasmuch as no specific details about the left out application is mentioned And there is no formal communication from the office of the district social welfare officer Kachar. In fact, in the affidavit, my lord, we have placed it before your lordship, my lord, but it was not properly considered.
Let us see the original record then. All the original record.
My lord, all the applications were, I can place it.
The details when the applications were received.
Lordship.
What is the mode of receiving the applications?
Lordship.
We would like to see that.
Yes, yes.
What do you say, sir?
I'll place it, my lord.
Because if people have been left out intentionally, unintentionally, by mistake, they have a right to cancel the recruitment. That is settled. They can very well do that. So
Only, my lord.
leaving, you see, Ms. Council, it's totally, absolutely unbelievable that against 4 posts, against 2 posts, only 4 would apply.
Well,
There's something fishy in the matter.
my lord, your lordship will consider another aspect. my lord.
Yes,
The reasons given in the impugn order that was before the learned single judge says that after the written test and the viva was over.
yes, information was
was
received.
given. My lord, our prayer was not for giving us appointment. It was since 1991, my lord, Shankar Das case, constitution bench, we don't have any indissoluble right. My only issue was before the learned single judge, if my viva was over. Declare.
Question here is, sir, that the very fundamental beginning of the process seems to be tainted. Applications of almost 357 candidates have been withheld. That would clearly give an indication that this was done to benefit only 4 people who possibly could vie for 2 posts.
My lord,
This kind of competition
my lord.
by depriving other qualified people who have filed the application, how it is acceptable?
My lord, now when it was pending for, because we have filed a contempt before the learned single judge.
Yes,
Contempt
we'll
was
stay the
pending.
order.
They, my lord, if your lordship stays this, my lord, what has happened, my lord? They have said that we have destroyed all the papers for 5 years is over. In their contempt, they have filed an affidavit. I will place this affidavit. before your lord.
What papers?
My lord, this is the affidavit. I am placing the affidavit. My lord, I am placing the affidavit. Your lordship may look into it.
We are asking them for the original record.
Yes,
My lord,
yes,
they
Let
have
us see
said
their
they have
response.
destroyed.
I'll print the report.
Let us see their response.
Yes.
All right. And council, government council, Mr. Nath, shall keep the complete original record
Lordship.
available for the court's perusal on the next date of hearing.
My lord.
Who is the officer concerned?
My lord, the Director, Women and Child Welfare.
The
Earlier it
director,
was-
social welfare,
It was earlier social welfare. Now same officer, it is.
director so and so
Social.
shall remain present in the court with the original record on the next date of hearing.
Lordship.
List on. Till then, the respondent shall not insist for the continuance of the contempt proceedings.
Lordship.
List on 26th April.
My lord. I'll place it. My lord.
Matter number 9,
May I please, your lordship? This appeal.
Yes.
May I please, your lordship? This appeal is preferred by the state lordship. The brief fact of the case is that lordship, the writ petitioner was enrolled as a home guard volunteer lordship. And during the course of his employment lordship, he sustained bullet injury fired by some miscreants lordship. Accordingly, he sustained 50% of locomotive disability.
Disability, okay.
And lordship accordingly is approached this honorable court by way of a writ petition claiming continuation of his service on the basis of that the Disability Act of 2016.
Mm.
The service condition of the home guard is that lordship under the act that initially lordship he is engaged for a period of 6 months which can be extended up to 1 year if the state government desires. Thereafter, he will kept as a reserve for a period of 3 years.
Mm.
And during this period, if he is required for some urgent work, lordship, he is again called and daily wage basis they are engaged.
It's a roster. Basically, they are given a roster.
Lordship. And lordship is home guard act, lordship. I tried my level best to get it from the local act, but I am unable to. But lordship, I have obtained it from the department. May I place this?
Yes.
And thereafter, lordship, in 2015, there are some amendments also there.
Hmm.
Hey, I don't know. What on earth to do this? I'm giving it to your lordship.
Yes.
5 minutes.
As counsel,
Lordship,
can your department consider granting him compensation? Because he suffered the injuries.
lordship,
You may be technically right,
lordship,
because home guard, basically it's not a service
lordship,
in so many words.
lordship,
Nor there is any pay scale.
lordship,
We understand that. But the man suffered duties
lordship.
suffered injuries while
Yes, yes,
serving you.
yes.
So why not on a humanitarian consideration,
Lordship,
offer him a reasonable compensation?
and lordship, no lordship, he has been thereafter lordship till 2015. Intermittently, he was allowed to work in some other places. And thereafter, by way of the interim order passed by this honorable court in the writ petition,
Mm.
he was allowed to work in the office of the SP office Nalbari. And
Office
the
desk duty.
procedure which we are following, he every day morning lordship he comes, joins, and in the evening he was discharged. That's because
Yes,
beyond that we cannot.
yes.
And only this appeal is preferred before this honorable court only on that I am not, we are not disputing regarding his appointment. That's because he is entitled under the Disability Act. Only our grievance is that lordship, he will be governed by the Home Guards Act.
Home guards, so far as is
The service condition.
granting him the number
etc.
of days.
Yes,
basically.
lordship. If your
Yes.
lordship directs us, lordship, he can be engaged in any other, by this way, lordship, he can be engaged, lordship. As because, lordship, we are also, but this person is already disabled, lordship, we also feel for him, lordship. But only that, lordship, where the honorable single judge is directed for continuation of his service, lordship. We are only on that, as because this should not be a precedent, lordship.
Yes.
If your lordship comes to the judgment at page 8,
Mm. Yes.
the honorable single judge has relied on the 20 subsection 4 of lordship. This may I read, lordship? That is reflected in page 10.
Mm.
May I read, lordship?
Yes.
No government establishment shall dispense with or reduce in rank an employee who acquires a disability during his or her service, provided that if an employee after acquiring disability is not suitable for that post he was holding, shall be shifted to some other post with the same pay scale and service benefits.
Mm.
We are going to give him, lordship,
Mm.
service benefit. But lordship,
Then what is
he
your
cannot be
grievance?
continued.
What is your grievance against the imperial order?
The grievance, lordship, may kindly come to page number 12.
Hmm.
Last paragraph, lordship. May I read, lordship?
Yes.
The Director General of Police as well as the Director General of Civil Defense and Commandant General Home Guard to take a conjoint decision as to in what post the petitioner shall now be placed so that he can continue with his service as indicated above, and the place of posting shall not entail a service condition which would be lesser than what the petitioner was earlier subjected to while he was in service.
Mm.
We again clarify that the terms and conditions of continuing with the service, continuation, lordship, as because beyond 4 years, he cannot be taken in the department.
You need to prepare something more, Mr. Counsel.
Lordship, as because it's an
There are
act of
Supreme Court
1947.
judgments. There are direct Supreme Court judgments that basically home guards are not in a government service. It's not public employment as such,
Lordship.
because there is no regular process of selection,
Lordship.
nothing like that. There is no regular entitlement of duties even.
And,
So-
and 2015, there was an amendment, lordship. Earlier,
Yes.
it was 4 years. After 4 years, a committee, they will decide whether he is still fit, that person is still fit. In that case, lordship, he can, and the age is also reduced to, earlier it was 20 to 55 years. Now it is reduced to 30 years. So that
Okay.
beyond that period, lordship, we can try for any other job. But it's
Yes.
the act of 1947, lordship. It's a very old act. It should be.
You come out with some Supreme Court judgments. There are judgments. We are telling you,
Lordship,
you prepare the matter, come out with few judgments on this issue.
lordship.
Counsel for the appellant, please for time to prepare the matter and argue the case, argue the same before this court. List of 2 weeks.
Lordship. May I pray for a date, lordship? After Bihu, lordship, if it is not inconvenient to your lordship.
26 April.
Lordship, much obliged.
Matter number 10,
May I please, your lordship? Lordship, in similar matter, the appeal have been tagged with writ appeal number 44 of 2023. This may also be.
Fair price shops. The council submits that identical appeals are pending consideration of this court. Registry shall tag the instant file with the file of writ appeal number
44 of 2023.
44 of 23 and list both the matters together.
Obliged.
Matter numbers 11 to 29 for order.
What is the category? Service. Okay,
Malaj, the matters are listed in the orders category, Malaj.
yes,
We have been able to reconstruct the files. So Malaj, we found out that there are fresh steps that we need to take for Malaj 5 matter items, Malaj.
in five appeals.
5 appeals, Malaj.
Okay.
Item numbers 11, 25, 26, 20.
Service, in this bunch of appeals, service has not been affected on the respondents in so and so.
Malaj.
And counsel for the appellants to take fresh steps within 7 days,
Malaj.
whereafter process be issued to the unserved respondents. You want Dasti?
But we'll take normal.
Dasti service is permitted. Rule is made returnable in 8 weeks.
Deeply
I think so far, item number 18 is concerned. I was appearing for the other side, but I've handed over the brief, but I'm no longer appearing in item number 18.
Miss Counsel, Mr. So-and-so, you have handed over the brief to some other counsel, submits that he no longer represents the respondent and that the brief has been handed over to counsel Mr. So-and-so, Mr. So-and-so.
Deeply
Item numbers 14, 15, 16, 17, 21, 22, and 23. Name of senior advocate Ms. M. Hazarika has been reflected in the first list. We do not have any contact with the clients and we do not have the briefs, so the petitioners may take steps on them.
Okay, in items number so-and-so, the council, Mr. So-and-so states that they do not have any contact, the clients are not in contact with them, and thus, fresh notices may be issued to the respondents in these cases. In this view of the matter, counsel for the appellant to take fresh steps for the respondents in these appeals as well.
Deeply obliged.
I am making for the respond number item number 20 and 27 for the
Sir.
respondent. So on the date, Lord, in item number 27, I have not received, in item number 20, I have not received a copy of this.
Copy you may ask your colleague, he'll provide it.
Malaj, I'll provide.
Obliged.
Okay.
What do you-
Yes,
Item numbers 31 and 32.
May it please, Malaj, your lordships will permit me to appear online, Malaj.
yes, definitely.
I'm so grateful, Malaj. Malaj, this is a non-adversarial litigation, Malaj, on the implementation of the provisions of the Juvenile Justice Act, Malaj. If your lordships permit, I'll give a slight background because your lordship is dealing with the matter for the first time. Now, Malaj, what had happened? There was a PIL filed by us, that is Sampurna Behura, Malaj, before the Honorable Supreme Court, Malaj,
Yes.
wherein several directions with regard to the implementation of the Juvenile Justice Act was passed, Malaj.
Yes.
And there was a separate direction in that, Malaj, whereby the Honorable Supreme Court requested the High Court, Malaj, to take up these directions suo motu, pursuant to which, Malaj, a suo motu petition was also registered, Malaj.
Yes.
Now, Malaj, initially, the state was asked to file a status report, wherein, Malaj, reply was filed on all the 16 directions or recommendations by the Supreme Court.
Mhm.
The amicus, Mr. Das, H.K. Das was appointed the amicus, Manoj. He's very graciously filed a detailed Malaj status report dealing with all the Malaj 16 points. But what happened thereafter, Malaj, is that the focus from these 16 points changed into only one, which is Malaj child-friendly courts. As a result of which, the implementation of all the other 15 points, Malaj, stepped aside, Malaj. If your lordship sees, Malaj, I had filed another PIL, Malaj, which was tagged to the suo motu petition, which is PIL 60 of 2019. I am the original petitioner before the Supreme Court, my lords, and I had filed an additional affidavit, my lords, for your lordship's assistance, whereby I had collated, my lords, all the status report filed by the government and the directions, my lord, and placed before this honorable court in the form of a chart the various subsequent directions that may be required to be passed. Would your lordships be kind enough to see my additional affidavit, 16th of December 2022, my lords?
No, it's okay. The affidavit will be in this file only.
It'll be in the next file, my lord, item 30. I mean, in the 60 60 of 2019, I believe, my lord.
Item 31, madam.
31.
Yes, we are having that file only.
I am so grateful, my lord. Your lordship sees the additional affidavit filed by me, my lord, on 16/12. And if your lordship goes to page 7 of that, my lords. Your lordship has page 7 of that, my lords. Internal
Yes,
page
yes.
7. Yes, my lord.
Hold on.
I'm so sorry.
The internal pagination is not done. That's what.
Oh, my lords, the typed page number, it's a typed page number. My lords, may see para 10, my lords.
Para 10.
Yes.
This is affidavit of Sampurna Berua.
Yes, my lord. So it is an affidavit filed in that matter, my lords. Yes, my lords. I'm so grateful.
Yes.
After para 10, my lords, what I have done, my lords will note that there are 3 different affidavits filed by the state with regard to the status report. I'll just voice out the dates, my lords, for your lordship's convenience. That is 28th of February 2019, 14th of August 2019, and 4th of December 2019, my lords. This council appearing for the state will correct me if I'm wrong, my lords. Now, my lords, the first direction is with regard to, and I have extracted the direction of the Supreme Court. Your lordships will take it from me. This is purely an extract from the judgment of the Supreme Court. Now, the first direction was regarding the implementation and filling up the various vacancies in the SPCR and SCPCR, my lords, of the state authority. And this is required, my lord. I have also stated the legal provision in 1.2, my lord, which mandates the filling of the post, my lord. And the affidavits, my lords, clearly show that all the posts are not filled up, my lords.
Just before we proceed further, would the state like to respond to this?
Lordship.
You have received a copy.
Yes, my lord, I have received the copy. my lord.
Why haven't you responded so far? Probably we have changed tracks. We have gone to the vulnerable witness center and all those things. So, but this is the fundamental issue in these petitions is regarding childcare institutions. So we need to focus on that first.
Yes.
So when would you be responding?
Lordship may give me 3 weeks time. my lord.
Mr. Sharma will give them 3 weeks time.
My lords,
Then
I would only request if you meets your lordship's indulgence, my lords, let it be expedited because we have lost 3 years. All the other states, my lords, have gone ahead and implemented everything, my lord. Yes.
Mr. Sharma, we know we were taking up the suo motu matter in Rajasthan.
Oh,
And we have,
yes, yes.
we have passed many directions.
Yes, yes.
And,
I'm so
and
grateful.
if you recollect, Honorable Justice Deepak Gupta, in his
Yes, sir.
farewell speech, referred to the Rajasthan system as the best in the country. So
Oh,
we
yes,
will
my lord.
ensure this happens here also.
I'm so grateful, my lord. I'm so grateful. My lord,
On
the
the other,
sad
you were-
part is,
You were not there on the last date. Otherwise,
Yes,
we would have been apprised of this affidavit. Now
Yes,
we
my lord.
will tell the State Council to respond to this affidavit immediately.
yes, my lord. My lord, just one small, just 30 more seconds, my lord. My lord,
Yes,
in
yes.
my petition, I had also raised certain very other important points. Like, my lords, there are no rules framed in Assam, like the juvenile justice rules hasn't been framed. There is no child protection policy, my lords, and there is not even, my lords, a status report, my lords, social audit done. These are all
Social
requirements, my lords. My lords, let them answer on those points also.
Mr. Sharma,
Yes,
can you briefly prepare a list of what issues need emergent addressing? So
Yes,
we will
ma'am.
ask the state to respond on that.
Yes, my lord. My lord, that is there. If your lordship sees my affidavit itself, my lord, that is
Yes.
there, my lord, from point number, my lord, 20 onwards.
Six.
Page, my lord, if your lordship sees that chart, which starts at page 7.
So all right, let us ask them to respond to your entire affidavit.
Yes, my lord.
Let's receive
Absolutely.
the
I'm so
response
grateful.
And we'll carry it forward.
Yeah, I'm so grateful.
Learned Counsel, Mr. Sharma, appearing through VC, has taken this court through the additional affidavit, contents of the additional affidavit dated 15/2/2022, highlighting the shortcomings in the juvenile justice system, which are required to be gapped, the plugged by the state of Assam. Addressed, लिख दीजिएगा. Learned Government Council praised for and is granted 3 weeks time to file a detailed response to this affidavit, explaining the steps, if any, taken by the state of Rajasthan
Yeah, well, let's go Assam.
in accordance, state of Assam in accordance with the directions given by Honorable Supreme Court in the case of Sampurna Behrwa. List on 27th April.
Lordship.
I'm so grateful, Malad. It's a pleasure, Malad.
Okay, this is okay. This is okay.
You, Mr. Nath, you also give the status regarding the vulnerable
Yes.
witnesses,
Yes, yes.
wherever the things are there.
Yes, Malad.
Please have them completed because that is Supreme Court's mandate.
Lordship.
Okay.
I'm so grateful, Malad. It's a
Yes.
pleasure.
Vulnerable witnesses and child-friendly courts.
Yes, yes, Malad.
They all the aspects.
Including the
need to be
deposition
addressed.
center and the issues pointed out in the affidavit. Malad.
Yes.
Lordship, we'll respond.
Re-notify on 27th April.
Lordship.
Item number 33.
Made his lordship, on the last occasion of 27/2/2023, lordship,
Yes.
an order was passed whereby an additional affidavit was supposed to be filed by respondent number 5 to 10.
Hmm.
And through office note dated 27/3/2023, we find that
Yes.
5 to 7 and 9 and 10 have not filed an affidavit.
Yes, please.
5 to 10, my lord, I am representing my lord.
Yes.
Affidavit filed by the 7 and 8, my lord. There is the principal secretary and the joint secretary, they are representing them. I'll look into whether another affidavit.
If you
is required for
need
them or not.
to file an affidavit or
My
not.
lord, if it is required, we'll file it, my lord.
What do you
Let's
say?
take it.
Land Council, Mr. So-and-so, appearing for the response numbers 5 to 10, submits that affidavit has already been filed on behalf of the response numbers
7 and 8.
7 and 8, so-and-so, describe the name of the officers. And that he would go through these affidavits and then take a call whether affidavits are required to be filed on behalf of the response numbers
9 and 10, in view of the fact that 5 and 6 is the political person.
9 and 10.
9 and is the political person, 5 and 6, my lord. My lord, and the road has already been, my lord, national highway has already been completed. They can file the affidavit that whether the road has been completed or not, national highway authority, my lord.
He further submits that the road in question has, national highway in question
National highway.
has already been completed. The status of completion be filed on record by the next date. List after 3 weeks. Status report.
Item number 34.
Yes.
My police, your lordship, my lord. Pursuant to the order dated 18/1/2023, my lord. My lord, we have filed an affidavit, my lord, regarding service of goods after respondent number 6 for Dosti, my lord.
Report. Yes, service is complete.
Yes, my lord.
Yes. You appear for
Respondent number 7 and 8, my lord.
7 and 8. No one has appeared for respondent number 6?
No, my lord.
All right. As per the office report dated 29 March 23, service of notice has been effected on the respondent number 2 by Dasti.
Respondent number
Thus-
6, my lord.
Respondent number 6. Thus, the other respondents are already served list the writ petition for admission after 1 week,
After 2 weeks, madam.
after 3 weeks rather.
The number 35,
Yes.
May I please, your lordship? My lord, there was an application for condonation of delay of 54 days, my lord. And my lord, we have carried out publication in this matter. Because
Publication?
Yes, there are 332 private
Okay,
parties, my lord, landowners.
so
I filed the affidavit, my lord,
okay,
enclosing the publication. My lord.
the then counsel for the appellant has filed an affidavit regarding publication service upon respondents by publication in the newspapers. The registry shall make a report and list the matter after 2 weeks.
May I request for a specific date, my lord, consultation, my lord?
List the matter. When do you want?
My lord, could it be in May, my lord, middle of May, 18th of May?
On 18 May. If service is complete, comma, the registry shall report. If service is found to be completed, comma, list the matter for admission. List the, no, this will come up on the condonation only. List the matter on 18th May.
Deeply obliged.
the number 36.
In the appropriate category. Yes.
May I please your lordship? Lordship, as per office note dated 29 March, lordship, service has, notice has not served, lordship. Due to sole respondent has not resides in this address, lordship.
Then you have to provide the fresh address.
Lordship, some time may be granted for taking fresh address from the.
Counsel for the appellant. Place for and is granted 4 weeks time to provide present of the current address of the respondent upon needful being done and requisites being furnished, comma, let process be issued to the respondent on the new address provided by the counsel for the appellant.
Obliged.
Yes.
The number 37.
Yes.
23. Lordship, there has been a delay of 23 days.
Unknown.
Lordship, this appeal may also be tagged along with writ appeal number 44 of
All right.
2020.
This writ appeal is delayed by 44 days.
Lordship,
counsel-
23 days.
23 days. And counsel for the appellant has moved interlocutory application under section 5 of the Limitation Act seeking condonation of delay, which is not opposed by land counsel representing the respondents. The grounds set out in the application are germane and hence the same is accepted. Delay is condoned. The registry shall number the connected appeal and please tag the same with writ appeal number 44/23.
Highly authorized.
Registry is over. Matters are. The registry is restricted or what? No fresh matters are coming. Okay.
Kindly come to the last order,
Yes.
20 March. First, I want to make two corrections with your lordship. Your lordship will see the conclusions arrived at by the NHIDCL after the deliberation have been placed on record in a seal cover, which was opened in the court as part paragraph K. My lord,
Yes.
it should be J,
All right, we'll rectify it.
right?
Yes,
And second, my lord,
yes.
however, a proposal for undertaking the balance work by a joint venture bid was also considered in the meeting. And in this exercise, proposal submitted by Villela Kamu and Sons to complete the works by way of joint venture along with MS Chabu and Co was found to be viable. My lord, this aspect, your lordship, let me, I put it in this way. There's an anxiety has been caused in the headquarters that as if it is coming through the NHIDCL.
No, we'll make it clear
My lord,
that the anxiety is on part of the court, that we should get the work completed somehow or the other.
now, my lord, I hope your lordship will appreciate what
The direction will be coming from us,
my lord.
but you just let us know the viability part of it.
My lord, I am placing the communication which I have received.
Yes.
This is, no?
Firstly, where is the report? Let us see the report. This is 19th March.
The order was of 22nd March, my lord.
Yes, where is that report?
My lord, this is the instruction which I have received.
No, this is today's instruction, which is the report which is referred to in the earlier order. Where is that report?
My lord, that is a submission made by Chabu and Co contractor with respect to their deliberation which they had on 17th of March.
That is their submission.
That is the
only.
My lord, it is the submission and it was in the minutes of the meeting, my lord.
Where is that meeting minutes? Where are the
I have given on the last occasion, my lord.
Where are the minutes? 21st. Yes. Not qualified. Okay. So this was only the oral submission.
My lord.
We'll clarify. Don't worry.
My lord.
We'll clarify.
And your lordship, in pursuance to that last order
Yes.
of 22nd March 2023,
Yes.
your operating portion, your lordship will kindly come to page 2, second
Yes.
last para.
Yes.
In view of the above, we direct the NHIDCL to objectively consider the viability of the joint venture bid submitted by Vilele Khamo and Sons, along with MS Sabu and Co. in light of clause 2.1.11 of the RFP. The required exercise in this regard shall be completed within 7 days from today.
Yes.
At interim order of the phrase NIT shall remain in currency.
Yes.
Re-notified today it was. My lord, we did our deliberations, my lord,
Yes.
and we have forwarded it to the headquarter. The headquarter is saying that we will go by the NIT.
NIT. Viability aspect not considered.
My lord, there is a minutes of the meeting, my lord. The lordship will kindly see in the second page. We have placed it on records, my lord.
Just. Draft minutes of the deliberation forwarded by the RO Kohima
My lord,
has not been approved.
my lord.
What is that?
Draft resolution, my lord, you will find in the minutes of the meeting. Third page.
Third page.
My lord.
Okay.
May I read it, my lord?
Just hold on. Is qualified.
My lord.
Hmm.
My lord, what is the apprehension is there, my lord? Let me be very fair. The NHIDCL is thinking that better way is go with the NIT.
And delay the project by another 4 years minimum, right?
My lord,
Destroy the progress which has been made. Why this adamancy? What is the reason? Do they see better prospects for themselves in the new NIT? Should we put it that way?
my lord,
What is the project cost as per the new, what is the price quoted in the new NIT?
146.
And
146, but as far as this particular way, we have come down to 119.
so there is a direct gain of almost 30 crores, 28 crores to be precise.
Because from 146, why you have come down to 119? Because they have done certain amount of work.
So for the fresh tender, you will not take into account what they have done. That's the direct implication.
My lord.
So as an officer of the court, what would your view be? Forget your brief for the moment. And as a resident of the area, both.
My lord, as an officer of the court,
Yes.
I owe allegiance to this institution.
Yes.
But your lordship will be alive that there are certain things which I cannot cross also. But to be very frank, what your lordship has taken a call on last occasion, couple of months back, when Brother Justice, Honorable Justice Jamil was, we all were appreciative the thing. But your lordship might understand our thing also, because the RO office in Kohima, we are not that they are not the competent person to take the decision. It has to come from Delhi.
So you could have had the joint venture bid analyzed by people at Delhi? What prevented you from doing that?
My lord, it was asked to deliberate, deliberation was asked to be done at Kohima only. Deliberation was asked to be done at Kohima only, my lord.
We hereby direct the NHIDCL to objectively consider. Did we restrict it to Kohima?
My lord, in pursuance to this order, we had a deliberation in the headquarter also. The
Yes.
headquarter was duly apprised of everything. Then your lordship headquarter had certain queries with respect to, if your lordship see the letter which has been sent to us to put it before your lordship, that with respect to the observation and J and K. Now, second aspect was that it was being directed that, okay, you have the deliberation in the head office of RO Kohima.
Yes.
So we had our deliberations, and after that we forwarded it to headquarter for taking a
Yes.
call.
Yes.
Then the headquarter thought that it will be best interest will be to go with the NIT, because 4-lane in the
All right, you give us a guarantee from the headquarter officers with all their affidavits that they will complete it within the schedule period, otherwise face prosecution. What do you say?
that will be very difficult.
Will they be able to file the affidavit?
I won't.
Is too much? Is the public importance or public convenience of greater importance, or their absolutely adamant stance?
My lord, as an officer of the court, I'm putting the facts. Rest I leave it.
Okay, Mr. Counsel, we understand. But which is of greater importance?
Of course, the public interest.
Then
2-lane connectivity is there. It is what is the
now let them forget the 4-lane. Your state doesn't need it. Rather, you don't deserve it probably. We are trying our best to get the things done. These people staying in Delhi, they don't know the hard realities. Make them travel on a 2-wheeler on that road. They'll understand what happens. We should give that direction. That ask them to travel in probably a jeep having minimum of suspension on that road. What will happen? They'll all be there with broken spines.
My lord, I will request this court.
Yes.
I will request this court. Let this court not come heavily on us. Your lordship may pass any direction,
Yes.
authoritative directions, so that at least NHIDCL is also saved. All the
We-
works are
we
done
are-
in a proper way.
Mr. Counsel, things are before you. It's your deliberation. Your RO, you don't say that RO is not competent. Have you said RO is not competent to undertake this exercise? You could have got it done by another body. The ones who suit you, who are competent as per you. And if they are not competent, why you have posted them there? For what purpose?
Decisions are taken in Delhi because the GM is here, my lord. GM is here. He's saying that.
Mr. Counsel, decisions are taken in Delhi. We don't want to comment on people having what kind of wisdom. You don't take our comments on that.
My lord.
We have done these exercises in Rajasthan and we will do it here. To our mind, the convenience of public is of paramount consideration. They are answerable to the public, not to their clerks. Plain and simple. These are objections which are put up by clerks in every government agency, in every government office. We see it time and again. What do you say, sir? Yes. As you are for Chomo and Company. We have the amicus curiae. We'll like to hear this arguments, learned amicus. Yes.
Amicus here. This is the, my lord, this is the 50th time the matter is the 50th time this court case is listed for various orders. 50th
Yes.
Since 2019. Now,
Yes.
2 in 90 has failed. And this is the third attempt.
Yes.
My lord, that view of the matter, this honorable court had took up this conscious decision to go for an out of the box solution. Accordingly, my lord,
Yes,
attendance work then is completed. And this,
yes,
and my lord, it was the suggestion has come from the NHITCL for this proposal, which is ongoing. So, my lord, we are not expected to blow hot and cold on the issue. So, my respectful submission that at the greater interest of the public at large,
yes,
my lord,
please.
direction should be given to the NHITCL to ensure that this process is completed logically. That is
Yes. So are you ready to back your stand that the fresh NIT will fetch positive results? Can you predict?
The GM wants to make a submission.
Yes. Yes.
Sir, we started the activity of calling the notice for tender for the balanced work, which previous two contractors could not do, sir.
Yes.
This was started in the month of December, sir, after the Honorable Court. Our deliberation with ECI was not successful.
Mm.
Sir, in the month of February, 2nd February, we uploaded the NIT for balance work. We took our decision, sir. We means NHIDCL, sir. Sir, on 20th of March, that bid was supposed to be opened, sir.
Mm.
But the Honorable Court had directed
Yes.
1 week before that, going for deliberation with the President.
Yes.
So the status of road today. Just a word about why 146 CR came down to 119, sir.
Yes.
Sir, 146 was based on all the balance work which was to be done after two people left. 119, why? Because initially the MNR contractors' scope was very less. Then G20 was announced.
Mm.
The government of Nagaland and Delhi, the ministry over there, sir,
Mm.
they asked us to improve the specifications. We improved the specifications to the best possible.
Yes.
So that work which has been done now has been now brought down to 119, sir. That work has been certified by the authority engineer that it is meeting the specifications, sir.
Yes.
So today, sir, with due respect, sir, today the condition of 2-lane road out of 4 lanes is very good, sir. It may be certified by the, they have. So we are in a very good condition today, sir. My only request to you, sir, what NHIDCL wants, that balance tool, it's not pressing, the connectivity is there. The balance 2-lane can come up in due course as per the specified procedures by Government of India, sir. That's my submission.
How do you qualify the due course?
Sir,
Do you have any assured statement to give to the court that yes, we'll do it in this time?
Sir, I'm not.
Then what kind of statement do you expect us to record? What do you mean by due course? Explain.
So the term, sir, if you permit, sir, the term of the contract is 2 years, sir.
Yes. How many contracts have we seen on this road? Of which the term was defined? How many? Please don't cut a sorry figure, Mr. Director. Please don't cut a sorry figure. You know very well what the fate of this road is. You must have gone there.
Sir,
You've been there.
I'm there only, sir.
Okay, you're there.
I'm coming from.
What kind of conditions do the contractor work? What kind of disturbances are there? What kind of weather is there?
My lord, my lord, I will take what your lordship, I hope your lordship will appreciate this thing, that we are not adverse to this, we are alive to the peculiar things, my lord. But the thing is that, to be very precise.
What is required to be done in a particular manner has to be done in that manner alone. You want us to
My lord,
stick to that principle, right?
my lord,
So we are asking you, what is due course?
it will take
Due
time.
due course in this high court means the appeal comes up in 3 years. Due course in Rajasthan, it means the appeal comes up in 30 years. So what should be the due course for this road to be completed?
My lord, I cannot give an assurance, my lord.
Then what is the purpose of your adamant stand? Here we have the contractors who are saying that we will do the work. One has performed. You yourself say the 2-lane road which the contractor has maintained is satisfactory. It meets the specifications. Then why not think objectively? Why not think about the plight of the people? I am new to this place, but I can very well visualize why this court was compelled to take up this matter so moto.
May I be permitted, Lordship?
Yes,
No, Lordship, when the amount was reduced from 146 to 119.
Mm.
Lordship, in fact, if we are to argue, as MS Chabu and Co. in joint venture, Lordship, if we are to argue, the 119 crores, that is also without considering the 2 years of escalation, that is 22 and 23, Lordship.
for that you have agreed.
Regardless of whether we make huge profit or not, Lordship, we accepted, and for the work that we are already executing, the maintenance and repair works, Lordship, they are also outside the scope. We are doing additional works to make sure that the traffic is not suffered, Lordship, and people do not suffer
Yes,
by commuting the road.
yes,
In fact, the breach at Zubza also, Lordship, the additional work that we have done by the normal maintenance and work, Lordship, the breach was in danger. So we have, without payment, we have strengthened the breach, Lordship. And we are
Right.
continuing to do that. As far as the road repair is concerned, it's almost complete. Some small additional works are
Yes.
there, Lordship. And regardless of looking at
Your
the
let-
amount of profit, Lordship,
yes,
we have done it, Lordship. Now, at this rate, now we have qualified, and my lords will kindly appreciate this fact that since 14th of February, 14th of December 2022, Lordship, that order, 19th of December 2022, Lordship, my lords have already looked into this aspect, and my lord has also expressed your lordship's opinion on 14th of March proceedings also, Lordship, about the successive NIT failures, Lordship. Now, my lord, the people of Nagaland wants good road, and this road is not only for the state of Nagaland, it is
Yes.
also a lifeline for the state of Manipur, Lordship.
true, true.
We're trying our best, Lordship.
And now your letter harps upon the typographical error in the order.
Your lordship,
That's simply you could have said orally. Do we need to bring it in writing? It's a typo, plain and simple.
the authority wanted me to place it before this court. I hope your lordship will understand.
That's what we are saying. The approach of your authority is pedantic, to say the least. Absolutely.
In my folded hands, I will say, my lord, your lordship may not take any adverse opinion on the NHIDCL. Then your lordship may
This
pass.
is, I tell you this, mentioning this typo and highlighting this in the letter, that is sick on the face of it. You should have thrown out this letter immediately. Do you need this to be brought on record by way of letter? That's if there is an error. Instead of J, type is, the K has been transcribed in the order. Please make a correction. You need to mention it in the highlight, 2 paragraphs in your letter. What kind of, we really are sorry to say, what kind of people are there who want to do a hair splitting exercise? Brother, what do we do? All right. We'll pass the order. We are directing that the rest of the work should be completed by the joint venture.
My lord, then in that case, your lordship.
Yes. And if you want, we'll make a comment on this letter also. We'll make a comment on this letter.
Okay.
You are inviting comments, or we can make the correction on your oral request.
Let me be on my oral request, my lord.
So then you take this letter back with you. And we'll record your oral submission. You can put the minutes for us. We'll take care of the minutes and we'll direct that the rest of the work will be completed by the joint venture. Yes, his application is there. We are coming to that.
Your lordship, in that case, my lord.
Yes.
In that case, let me be very clear, my lord.
Yes,
I am taking this call independently, my lord.
yes, yes,
In that case, my lord, let the letter also be, communication be also put on record.
yes,
Because.
you're right. So that we can make a comment on the approach of the authorities.
That I won't say, my lord.
You need not to say.
Because I have done what, as I've been instructed, my lord. As I've been instructed, the gentleman is here.
We are not making comments on you, Mr. Hansen. We know, we understand. Your anxiety as a citizen of the state is, we know very well, is that the road should be completed. That is your prime objective in your personal capacity.
My lord.
So we'll take care of the things. What about his application?
My lord, I have received the instruction, my lord.
Yes,
Yeah, my lord, what
Yes.
happened in this matter?
yes,
Kindly peruse these 2 emails, my lord. The gentleman has issued me the email. Your lordship, the amount of 11 crore which was been foreclosed
Mm,
in person to the order dated 28
Yes.
September, my lord.
yes,
Now OSCs is supposed to, my lord, OSCs moved out. OSCs have moved out and they have instituted an arbitration proceeding.
yes.
Now, your lordship, the total recoverable amount as per final termination payment, my lord,
Mm.
they stand at 19 crore 84 lakhs 92,360. That is recoverable from them.
Yes, but that is subject matter to the arbitration
Arbitration.
proceedings.
So now
Yes,
the LD amount of 11 crores, like which was deposited by them, my lord,
yes,
in person to the High Court's order and confirmation of the Honorable Apex Court.
yes,
uh, This matter, this amount, your lordship,
yes.
instead of releasing them directly now, let this amount of issue be a subject matter of the arbitration only.
That will always remain. But issue is, what about the liquidity part of it? Where does it remain? Where do the funds go?
The fund has been, my lord, as per
It's your case that we have an outstanding of 98 crores. He would say that I will be charging certain money from you.
my lord,
So that is the arbitrator to decide.
my lord.
We can ask them to provide solvent security for this amount which you have quoted. What is the problem?
My lord, because we have to be assured because
We'll ask them to
protect my
provide,
interest, my lord,
we will ask them to provide solvent security for this amount.
my lord.
Or what, Ms. Chug, why not a bank guarantee?
Manoj, the challenge with the bank guarantees, and before I say that, Manoj, I have a 60 crore tentative claim against them in the arbitration. And they also talk about a counter claim as the figure that my learned friend mentioned for the first time, actually. They've not taken that up in the arbitration so far.
Okay.
Manoj, in this case, it is not just about those 11 crores, if I may. Because there is a 3.5 crore bank guarantee that they've taken. 8.5 crores are the funds withheld for works that I've admittedly performed.
Mhm.
And then this is over and above the 60 crore claim that I have. They've declared me a non-performer.
So
This is again in challenge today.
solvent security.
My lord, your lordship, let me.
Yes.
What my friend is putting it. These issues what he is raising, making a submission, my lord. These are all arbitration issues.
That's what he says.
Precisely.
So now.
So why the court holds on to this amount?
My lord, this amount which it was held back by this honorable court because of the conduct they have done. And the suffering
That
which
conduct again is a subject matter of arbitration. That is a outcome of the contract.
let us give a bank guarantee or let me be protected.
Mr. Chuk, why don't you give the bank guarantee? What is it? And we will give the arbitrator to decide whether the bank guarantee should be continued or not after a particular period.
My lord, that is.
We'll leave you at liberty
Manoj, if I may.
to seek modification.
Manoj, in this case,
Yes.
my learned friend talks about the conduct. I'm not going into that.
We are not commenting on
That
that.
is the 28th September order, the order in question, Manoj.
Yes.
It directs me to liquidate the amount. Manoj, with great respect on the fundamentals. Manoj, this liquidation.
So
the
bank guarantee
cancellation of
would,
that order in the
bank guarantee would take care of the things. And we'll leave you at liberty to move the arbitrator for seeking modification of this condition during the course of proceedings.
My lord, they have
That is a
moved the
predicament.
application,
Manoj.
but it has been rejected by the High Court, by the arbitrator.
What
Or
They have asked for interim order to get this 11 crore.
obviously the arbitrator would not be able to do it because this is the
Yes.
court's, the order passed by DV
Yes.
of this court. We'll make it clear that even regarding the bank guarantee, the arbitrator would be at liberty to take a call at a suitable point of time.
This is absolutely incorrect. We've not filed any such application. Manoj, there's no application for release of 11 crores because we are before my lord's order.
We expect that he would not be filing
My lord, there was an application, interim application that has been filed.
for
Learnings. That's my lord's on the question of, if I may ask this. They declared me a non-performer, admitted position that the non-performer status, quote unquote, cannot outlive the contract. Both have terminated this contract. Second is an automatic debarment they've done. I moved the Honorable Delhi High Court in a section 9 for that. And the Honorable Delhi High Court has relegated
So
me to the tribunal.
Ms. Chug, what we'll do is, we'll release this fund subject to your providing a bank guarantee and leave you at liberty to move the arbitrator for relaxing that condition also in a suitable proceeding.
My lords, may also kindly then consider fixing a time limit for the learned arbitrator to be deciding that.
Not within our
My
jurisdiction,
lords, because the predicament that I am in, my lords, is this.
not within our jurisdiction, Ms. Chug.
My lords, the predicament is,
My
Yes.
second, third aspect, your lord.
allow me to, my lords, if I may just place one
You
point
complete
before
your,
my learned
yes,
friend, comes to this.
yes.
My lord, on this 11 crore aspect, my lord,
Yes.
if they were to, and ultimately at the end of the day, my lords have told us repeatedly and taught us repeatedly in terms of law that this is a disputed question of fact as far as the contract is concerned, directly covered by an arbitration clause.
Yes.
If the NHIDCL had to make out a case for retention of this amount or for deposit before the tribunal in an order 38 rule 5 or an order 39 rule 10 situation, my lords, they'll have to cross a very high threshold where they'll have to demonstrate that I'm going to run away. And prima facie, I've committed breaches. my lord.
That's why we are saying we are converting this into a bank guarantee and leaving you at liberty to move the arbitrator for relaxing that condition as per his own wisdom.
I'll be grateful, my lords, may just kindly then consider, since they've also taken a 3.5 crore bank guarantee. The bank guarantee that I have to furnish, my lords, pursuant to this order, make adjust and set off that amount. But my lords, otherwise it becomes a triple whammy for me.
How do we get that figure from? Where do we get that figure?
3.5 crores, my lords. I'll just point out the specific figure. Broadly, it's 3.5 crores. The bank guarantee they've encashed.
Where do you get that?
My lord, if there is one more submission, my lord.
Yes.
That on the very first, when I began with that the Vilele Khamo and the joint venture aspect, my lord, that should not be, they are thinking that it has been booked by us.
We'll make it clear.
Clear? And
Yes.
third aspect is there, my lord. There, as far as package 1 and 2 is concerned, they were supposed to complete the work by 15th of January.
Who?
Other contractor, ECI, Renke and ECI.
Okay.
They have not turned up on the last 2 occasions.
So you take action, whatever you want to do. They have not turned up in these proceedings.
And
So-
the work is also not been completed.
Package 1 and 2.
Package 1 and 2.
This
Because,
is the statement coming up for the first time.
my lord,
Earlier, we were given to understand that packages 1 and 2 are complete.
package 1 and 2, my lord, they, as per the last order, my lord,
Yes.
they are supposed to complete by 15th of January.
Yes.
We on their request, this court released the amount, directed us to release the amount. We have done our part, NHIDCL, my lord. They were supposed to expedite and finish it. But till now, on these 2 occasions,
So we will leave you at liberty to take suitable action.
my lord, let
in
it be
terms-
recorded. Right?
Yes. But on your oral submission, if at all the work has not been completed in terms of the contract, you take action.
My lord, referring to the earlier order,
Which order?
order of
Order dated
19 December, my lord.
19th.
Because they have made a commitment to the court, my lord.
Just,
Please, your lordship.
yes,
My lord, with regard to package 1 and 2.
yes,
there was
please.
the direction by this honorable court that the package 1 and 2 contractors should complete their work project by 15th of January. So my
Yes.
respectful submission, my lord,
Yes.
let the contractor for package 1 and 2 file a affidavit saying that the work is already completed on the next date.
Mr. Counsel, no one is representing that contractor right now.
My lord,
There's no one on its behalf.
I'm the amicus, that's why I'm making a submission. Let them.
We understand. Yes, we will ask their counsel to submit an affidavit.
My lord,
Yes.
that can be done, but lordship, why I am bringing it to the knowledge of this court, because there is a judicial order
Let's
and an
see,
undertaking has been given by them.
let's see the order.
19/12/2022.
12, brother. I don't see the order. 1812, yes, 812. थोड़ा उल्टा लगाया होगा order. One order is placed wrongly.
Kindly come to page 6 of the order, my lord, internal page 6. So it is passed in,
Yes. Yes.
my lord, is there?
Yes.
IS page 6, internal page 6.
Mm.
IS civil number 178/2022 was disposed of on 14/12/2022. In the said order, we directed the respondent number 8 to raise bills and have a joint verification with the NHIDCL authorities, and therefore the agreed amount of pending bills shall be released to him on or before 21 December 2022. We make it clear that while releasing the agreed amount, no penalty amount should be deducted from the said bill. However, such penalty amounts can be deducted in the final bill.
6, where is it reading from?
Taking into account the
There's no page 6. This order runs only in 3 pages.
no, my lord, this order has been passed.
Yes, all right. This is page 3 of the order. Yes, we make it clear that while releasing the agreed amount, no penalty amount should be deducted.
My lord.
Yes,
Taking into account the concession made by this court, we direct the respondent to ensure that the package 1 and 2 are completed on or before 15/1/2023.
yes. So you have been given liberty to deduct the amount from the final bill.
Final bill.
So you do that. Why do you need any further directions from the court?
My lord, my hesitation is that.
Yes.
My hesitation is that since they approached this court by an IA for asking for the payment, we paid the money without deducting the thing because in compliance of this order.
You have been given liberty to deduct the amount from the final bill. Have you cleared the final bill?
No, my lord.
So then do it. The order, liberty is already there. Why do you need our intervention in that? It's already clarified.
My lord, I am apprising this court.
That clarification is already there, sir.
My lord.
If I may, my lords, on
Yes.
respondent number 12.
Lordship, my respectful submission with regard to package 1 and 2, if I may.
Yes. Yes,
Lordship,
please.
Direction to respondent number 8, the contractor, to file an affidavit in compliance to the order dated 19/12/2022. That is direction to comply, the order done, which Lordship has just read, to complete the project by 15 January.
Sir, the issue is counsel for that respondent is not appearing either in person or through VC.
My lord, I will inform him personally that order has been passed.
You inform him, we'll take a note of your arguments. The order. Yes.
My lords, on the question of my application, my lords have been very patient with me. My lords, I've been told that a bank guarantee and having the cash essentially is the same thing because I have to maintain that collateral and
But
the liquidity in my bank account.
That's right.
But
So we
already
expect
I'm-
your client to be having that kind of liquidity in the accounts.
My lords, I performed, I'm not a fly-by-night operator by any means. I performed various projects, but the last few months and how this project has panned out has really stifled me financially. My lords, in
That's
that
why
background.
we are giving you liberty to make a prayer to the learned arbitrator to modify this condition, maybe after 3 months.
My lords, the difficulty in that situation also is
Yes.
that it almost places the order 38.5 order on me to begin with in an arbitration and for me to rebut that
But
presumption.
we
that is in that
will
sense.
give you liberty to do the further process before the arbitrator.
My lords, my lords have been very patient. My lords may then kindly consider reducing the amount of the bank guarantee that I have to give. 3.32 crores bank guarantee they've already encashed.
Where do we get that from? Again, the same question.
My lords, they are here.
Mr. Counsel, it's a fact.
My lord,
Bank guarantee of 3 crores is saying that
3.3
you already encashed.
did we encase it?
Yes.
Yes, it has been.
So we'll reduce that amount for the bank guarantee. 8 crores.
My lords may then kindly consider 4
8 crores. 8 crores. 8 crores.
My lords,
That's
difficulty.
sufficient.
My lords, the difficulty then is. My lords, this
Then
is,
we reject the application and leave you to go to Supreme Court.
my lords, I'll bow down to my lords' decision.
Okay. Thank you.
I'm so grateful.
Before my lords rises, I have a request,
My lords, I'm
lordship.
so sorry, my lords. My lords, kindly also dean plead me in that sense, my lords, from this matter.
Right. Okay.
I'm so grateful.
Lordships, while passing the order, my lords may also kindly fix the price.
119 is already there.
Yes, lordship,
So we'll approve that
my lord.
during the deliberations, 1 crore 19 lakhs has been settled. Is the
119 crore.
119 crores. We'll say that the work will be done on that settled price.
Lordship,
We need not impose ourselves in that.
lordship,
That is the decision arrived at after deliberations.
my lord,
We'll approve that.
lordships.
Okay.
My lord.
Thank you. Right.
Order be communicated to us through emails, my lord.
Yes, you give out a brief what you want to be incorporated. Otherwise, you'll again say that there is.
My lord, your lordship may understand my position, my lord.
Okay. That's why we are asking you to